Hi, my name is Jessica, and I'm going to be doing my assignment for Module 7 for Diversity and Culture. The first topic is going to cover University and Community College Systems of Nevada versus Farmer. This is a case from 1997. Farmer was initially awarded $40,000 in damages for violation of the Equal Pay Act. The university won an appeal in front of the state of Nevada Supreme Court, and the U.S. Supreme Court declined to hear the case, leaving the lower court's verdict in place. The objective of the student is to define and critique the findings of the Nevada Supreme Court and using a deontological or teleological approach. So the student's findings are that this was a deontological approach. A deontological approach is the normative ethical theory that the moral of an action should be based whether on the action itself is right or wrong and the understanding of a series of rules rather than based on the consequences of the action. In this case, the law set to place to ensure issues revolving around equality. On January 13th, 1993, Farmer filed a complaint alleging 4 cases of action. She first claimed that the university violated the Equal Pay Act by paying her an unequal wage for equal work relative to a male employee of similar qualification. Her second cause of allegation was due to race and gender violations, and this violated the Civil Rights Act of 1991. And then Farmer's third allegation was that under the employment contract, the university had breached it by promulgating policies and violating their own terms and agreements. Her fourth allegation was that they impiled confident under good faith and fair dealing. These 4 actions created a case in the court of law. When discussing the Equal Pay Act specifically, the salary should be lowered to make the 2 rates pay equal. The jury did verdict Farmer's favor of the first 3 causes of action, awarding her for $40,000 in damage, so they did not take the fourth into consideration. The second topic is regarding a company. The Watchmark Continental Corporation has undergone significant changes since their case of outsourcing. They were renamed Valent Corporation and later were acquired by IBM. This shows the competitive nature of the software industry, and based on the knowledge exam the outsourcing actions taken by the Watchmark Continental from the deontological and the teleological perspective. Many companies in the last couple of years have decided to outsource to China. Outsourcing has been a common practice among big companies in the United States. The teleological approach will lead to a good outcome. The company may outsource to cut costs of manufacturing, and this can also create jobs wherever they're outsourcing, though there can be pros and cons to both. The teleological approach is a theory of morality, and this derives the duty or moral obligation from what is good or desirable in the end to be achieved. So if the company is trying to achieve cheaper products, outsourcing to countries like China and India, Malaysia are common practices. If the company does outsource, the company will achieve a cheaper and more desirable end. Outsourcing will meet the goals of the company's product demands. The third topic is to present an argument that is easier for employers to comply with diversity legislation in Canada than it is in the United States. It is easier to follow diversity laws in Canada than it is in the United States. All other businesses are beyond the jurisdiction as of Canadian government and are affected only by the laws of the province in which they operate. For example, if Sears, the department store in the United States, which is a chain, you must follow regulations of the United States. So they must follow federal laws regarding non-discrimination, minimum wage, and so on. Each state does have its own laws with expectations. A company like Sears can ignore its laws because state laws are overridden by US federal laws. In Canada, this is a little different. Sears stores in Canada throughout the country are not federally regulated under the Canadian Constitution. So therefore, Sears must obey the laws of the province. So, like for example, Ontario must obey Ontario's laws, and Quebec must obey Quebec laws, so on which compliance the work of the stores. So Parliament did pass the Canada's Human Rights Act, which forbids discrimination by federal regulation employees on the basis of race, gender, sexual orientation, disability status, and certain other grounds. Since this act is there to stop discrimination, all of the different prominences do have this act. So typically in the United States, if there's an act of discrimination, we will go to the courts. But if there's an act of discrimination in Canada, they will go to the Canada's Human Rights Commission if the employer is federally regulated. By relying on the commission and the tribunal to hear cases instead of the court, the Canada approach allows victims to have a hearing without having to hire a lawyer, although monetary damages tend to be much lower than they would be in the United States court. So if a person in Canada felt that they were being discriminated against what had just been listed, then they would have the right to go to a committee versus going through the court system. Thus, this does make it cheaper and more personable for the citizens of Canada. In the United States, it would be a little bit more expensive and probably a little bit more time consuming getting through the court if you wanted to get your case heard. Topic 4. Select a source of media as outlined in Exercise in Media Diversity. Comment on the questions listed in the textbook for the media option you selected. So under electronic resources, there was one that was describing video games. And so it explained to examine 3 different video games, noting information about the principles of the characters. What I decided to do was I was going to compare and contrast 3 main video games, which is Call of Duty, Minecraft, and Fortnite. These have been circulating inside the media, and they're the most appealing to diversity because they're actually worldwide. So Minecraft is a game that consists of you building and challenging yourself, and there are many different skins. The color schemes attract people to the game. Same with Fortnite. There's many different aspects of this game that do tailor to diversity. Different skin colors, age-wise, color scheme. And then for Call of Duty, this can be a little bit more tricky. There are different race and ethnicity characters, but throughout the games, the common theme is that there is no characters anymore in these games. You find this with a lot of main media games, is there are no first characters or secondary characters. There's typically you as the player, and then skins that tailor to your liking. Though weight and generationism can be a problem with these topics because typically these characters do have a certain body type that it may not be realistic, and this can also be a problem. Most of the dominant audience for these games are male or children, but there has been a large increase of women playing these games. Action, there is a lot of action and aggression in 2 of these games. Minecraft, I think it's up to the parents to decide because this is a more child-aimed game. But these are the video games that I have examined and their principal characteristics. Thank you, and those are the 4 topics that we have covered for Assignment 7. Thank you so much for listening, and have a wonderful day.